Welcome back to FDVN channel. In today's video we will introduce a new vocabulary lesson on the topic of insolvency and winding up.
1. Listen carefully and fill in the blank. A. Insolvency. Charles Stanley, an insolvency lawyer, is advising a client. Insolvency describes the financial state of a company when its debts or liabilities exceed its assets and available cash. As soon as a company is insolvent, it must take action to resolve the situation. This may include renegotiating debt, realizing assets to discharge debt, or even borrowing more money and increasing the liabilities. There's a wealth of legislation that imposes obligations on company officers in relation to the interests of creditors. There are secured creditors, whose lending is protected by security over the company's assets, for example banks, and there are unsecured creditors, often suppliers, who may initiate action to achieve repayment. There are also preferential creditors, such as the company's own employees, for example in cases where wages haven't been paid, and occupational pension schemes. The options available to an insolvent company will be affected by the position taken by its creditors, and the various parties may seek legal advice. My colleagues and I often work on behalf of clients with a specialist accountant, an insolvency practitioner, also known as an IP.
Insolvency scenarios. A charge holder, see Unit 22, including holders of floating charges created since the Enterprise Act 2002, or the company directors file notice at court for an administration order. An order is made by the court appointing an administrator to take control of the company and to maintain it as a going concern. The company is then said to be in administration. Action initiated. A charge holder with a floating charge created before the Enterprise Act 2002 appoints an administrative receiver, an AR. Result: the receiver must realize the assets subject to the floating charge on behalf of the charge holder. The floating charge crystallizes and is treated as a fixed charge. Certain creditors will have rights in priority to the charge holders. A company in administrative receivership is often said to be in receivership. Action initiated. A creditor or company directors petition the court to make a winding up order. Result: the court makes a winding up order and the company is put into compulsory liquidation. A liquidator is appointed to realize the company's assets. Action initiated. Shareholders decide to put the company into liquidation when the company is still solvent, that is, has sufficient assets to discharge the company's debts. Result: creditors' voluntary liquidation. Action initiated. Shareholders decide to put the company into liquidation if the company is insolvent. Creditors accept the liquidator. Result: with the assistance of action initiated. Company directors, set out in an authorized insolvency practitioner, apply to the court for approval of a formal arrangement with creditors, as company voluntary arrangement, a proposal to pay creditors under the supervision of the IP. Result: supervisor, CVA, and appointment of a supervisor. 2. Listen carefully and choose the correct word in brackets to complete the sentences. 1. A creditor is a person or body owed money by a company. 2. The creditors may take action in relation to an insolvent company that will result in the company becoming subject to one of several insolvency regimes. 3. Suppliers are often unsecured creditors. 4. Employees and occupational pension schemes fall within the class of preferential creditors, who are entitled to receive certain payments in priority to secured creditors. 5. A liquidator is appointed by the creditors or the members to realize assets, which may then be divided up among the creditors. 6. If the company has insufficient assets to discharge its debts, creditors may decide to put the company into liquidation. 3. Answer the questions. Find your reasons at Part B in Section 1.
There may be more than one possible answer. 1. Who can initiate? A. A voluntary liquidation. B. A company voluntary arrangement. C. Compulsory liquidation. D. A company going into administration. 2. How can a charge holder obtain an administration order? 3. How may company directors obtain a winding up order? 4. What term describes the stage at which a floating charge descends upon the assets and becomes as though it were a fixed charge? 5. How could you describe a company that is actively trading? 6. What term describes the process of ending the carrying on of a company? 7. What term describes the state of being able to pay all debts or claims?